Please take your seats. For our final speaker of our conference, I wanted to end on a high point, and that's why I'm so glad that Mr. Blanchard agreed to be our speaker. This is another one of the A players that I invited. I had no thought that he might be able to fit it into his schedule, and then when sequestration, there's so many things that are going on, it's very, very difficult for him to get away. But, and it's not an easy job these days to be a general counsel of one of the military services. But Mr. Blanchard, I think, has brought a special talent to it. He had experience in the private sector, in the public sector. He's graduate of Harvard Law School. I think you're number one in the class, somebody told me. He's laughing, but that means he didn't turn and correct me, so I'm going to say that that's probably true. I hope you take some time to take a look at his very distinguished biography on the web. Speaking of the web, Mr. Blanchard did bring some slides, but I thought that maybe at this point in the conference, it would be more effective that if he made some remarks and then we focus some on the Q&A and so forth. And we will be posting, for those of you concerned about your CLE compliance, we will be posting the slides on the web to make them available to you. Mr. Blanchard?
Thank you. Well, thanks very much, Charlie, and thanks to Duke and Lenz, and of course, we have to thank Joy as well, and for the entire team, because this has been an amazing conference. I'm really stunned by the quality of every single panel, and I'm sort of up here scared, realizing that a high standard has been set. But the topic I'm going to talk about today is the ethics from the point of view of a government lawyer. And I try to give some thoughts about how I see some emerging themes and how I address those themes dealing with the sort of ethical requirements of emerging issues in national security law. And the way I'm going to approach this is first by not talking about ethics at all, but instead highlighting some of what we've already talked about today, some of the emerging practice areas that folks in my office are now grappling with, and folks in other parts of the Department of Defense, or even other parts of the U.S. government are facing, to kind of give context to some of the ethical issues I'm going to talk about. And then I'm going to, of course, have to get back to basics and realize that aside from these exciting new issues, we still have the joint ethics reg to deal with, and that does raise some serious issues for government lawyers. I'm going to talk a little bit about that. But then I want to focus on three issues that I think kind of have to drive a thoughtful government lawyer as they do their work. And those three kind of questions are, who is my client? Second of all, am I a mission enabler or am I a guardian of the law? And the third issue is, am I a legal advisor or should I and can I advise beyond just being a legal advisor? And hopefully I'll leave you with some thoughts as to how you should answer those questions in a particular area. So first, let's talk about national security law and what's sort of facing us right now. And I think the theme I want to leave you with is in a lot of areas, we don't have case law or regs or detailed analysis or court cases that really can answer a lot of these questions. For a lot of these questions, they are an application of long-held principles, such as described in the Talon memo for cyber, but otherwise there's a lot of decision space. And in some sense, this uncertainty, I think, will lead to some of the ethical issues that we are going to talk about at the end. So let me give some examples for the last 10 years. One of the early set of issues involved detainees, the appropriate treatment of detainees. Issues about, does the Geneva Convention apply? What is their status under the Geneva Convention? How do we approach Protocol 1? How do we approach Protocol 2? What does the Convention on Torture say? What is torture? And as you very well know, there was, in many ways, an outright war within the legal community, within the Department of Defense, on a lot of these issues, where there were sharp disagreements between lawyers. And that controversy continues to this day. I think many of you saw the movie Zero Dark 30, and I think I read more commentary on this movie by the human rights bloggers and the military legal bloggers than I read on any Hollywood kind of commentary. It's become more of a template for continued debate on the issue of enhanced interrogation and whether it's a good thing, a bad thing, is it torture, is it not torture, which evidences that these issues that we thought we had resolved in the early days of the Obama administration are continued dialogue within the legal community. A second issue we talked about at length already in this conference, and that is the whole issue of cyber. What are the rules in cyber? And I can tell you that folks here who deal with cyber within DoD, that our cyber operators are some of the most frustrated people in the world. And they hate lawyers right now, I think, because largely the interagency debates that are going on about what are the rules of the game with cyber have really seriously affected the effectiveness of what our operators can do and want to do, both offensively and defensively. So that's an area where the uncertainty in cyber is resulting in lawyers having to think through some of the questions I'm about to discuss. And finally, everyone's favorite topic, the drones, or as the Air Force likes to call them, remotely piloted aircraft. A whole host of legal issues involving these. Now, some would argue, and I think I'm in this category, is that it really is not any different whether you're talking about a Predator, a Reaper, or a F-16. The law is the same. There's not a drone-specific law. It really is about the law of armed conflict and airstrikes, and it really doesn't make a difference what air platform is launching the missile. The analysis is really not the same. So I would argue there is not a law of drones. But the use of UAVs has resulted in more capabilities, and that greater capabilities has resulted in some unique issues. And I would also argue that aside from whether it's a UAV or not, the very special kind of war we are now fighting against Al-Qaeda and associated forces, which is very different than your traditional state against state conflict, and even different than an insurgency kind of campaign that we fought in Iraq and that we're now fighting in Afghanistan. And instead is a very unique action such as in Yemen and Somalia and now in Mali. It does raise, because we're specifically targeting specific individuals, has raised some serious legal issues, especially with regard to U.S. citizens. And we saw, a flurry of activity with the release of the white paper that described, in general terms, the kind of analysis that was used in deciding whether or not a particular U.S. citizen could be a legitimate target under not only international law, but also under domestic law, setting up this criteria of that the person is an imminent threat with a very broad sense of imminence that is part of the unique nature of our current fight, whether capture is infeasible, and whether operation was otherwise conducted in accordance with the law of war. So all of these issues, what they have in common, whether it's the initial discussions of detainee rights in this kind of counterinsurgency against an enemy like Al-Qaeda and Taliban, whether it was cyber, or whether it's now targeting decisions in not even a counterinsurgency, but a counterterrorism operations, has raised a lot of legal uncertainty and a lot of debate and a lot of argument. And I think this has resulted, therefore, in several questions that need to be answered as we're facing this kind of uncertainty. The first issue is, who is the client? On any given day in my office, lawyers from my office and myself are an advisor to the Secretary of the Air Force. the undersecretary, the various assistant secretaries, the chief of staff, members of the air staff, or it could be even leaving legal advice to, on an issue of Air Force-wide importance for a leader of one of our Air Force major commands. So at any given time, we're getting conflicting kinds of people we're dealing with, and we have to remember who is the client. And the ABA model rules are pretty clear as to who the client is. The client is the Air Force. That is, the Air Force acts through people, but the Air Force is the client. We represent the organization, that's not the specific individuals. And this doesn't really become an issue until there's conflict amongst these various clients about how to approach a particular problem. And how do you resolve that? How do you resolve it when two assistant secretaries disagree about how we're going to deal with cyber? Or how do we deal with the conflict between a major commander who wants to do an operation and then the international affairs folks believe that is not an appropriate or wise use? Or how do you deal with the in the interagency when you have a conflict between different agencies about what the rules of the game should be for targeting decisions in counterterrorism? And I think the approach that we use is who has the authority to give the final word on this issue for the Department of the Air Force, which means that we have actually engaged in a major program of capturing all the various delegations that are within the Air Force, and believe me, it's about that thick, to really make sure that we are talking to the appropriate person who's been given the authority by either the Secretary of Defense, by statute, or by the Secretary of the Air Force to make the particular decision. But ultimately, even there, if the person has the authority to make the decision, even if it's the Secretary of the Air Force, if that client you believe is doing something that's in the short-term interest of the time, but long-term not the straight interest of the Air Force, it creates even greater kinds of issues. So that's where the need for independence really comes into play. And the ABA model rules actually talk about this, how a government lawyer compared to private sector lawyers has more authority to question government official action or conduct. And because they have the authority to do this, we have the obligation to do this. We have the obligation to raise issues that need to be raised. This issue of who is the client also, I think, raises some significant attorney-client issues. We have to make very clear to our clients when we're speaking to them that the client is not them, and the attorney-client privilege is with the Air Force, which means in some instances, the Secretary of the Air Force may decide to waive that privilege and release it to Congress, which has happened in several instances. So client confidences become very important. I think a second issue that to me is critical to the operation of a government lawyer is to what extent are we mission enablers, and to other extents to which we are guardians of the law. Are we enforcers of the law? Now I tell my team that we are largely there to be mission enablers. Our job is to try to get the mission accomplished in a lawful way, but our job is not just to sit back and pontificate on why certain activities cannot be done. Our job is to enable. Our job is to find a way to get it done. And one way we do that is we have our lawyers get in the meetings earlier rather than later so that we are part of the development of the policy, the development of the solution, so that we can say yes immediately. But sometimes we're not there. Sometimes the clients come to us with a brilliant idea that they want to execute in the next 24 hours that, of course, we're horror-stricken by because it violates 17 statutes and international law to boot. But by and large, our goal is to be a mission enabler, which means we need to be careful that we comply with international law, that we comply with domestic law, but we find a way to meet the mission. And we do that a lot. I mean, we are critical to the major weapon acquisitions. We're critical to making sure we have international agreements that meet the needs of the United States. And we're critical to every mobilization package to make sure that we mobilize the right people quickly. But sometimes, and these may be rare, but sometimes the role of a government lawyer, we can enable the mission in the way that we've been given the assignment by the commander. And that we have to take seriously our obligation to give legal advice that our clients may not want to hear. You know, we have to ask whether the particular operation is consistent with international law. We have to make sure that it's consistent with domestic law. And we have to make sure that if it's being done by an echelon below the secretary, whether it's consistent with DOD and Air Force policy, or the rules of engagement, if it's an action by an entity that's supporting a combatant commander. And so sometimes our answer is you really can't do that. We can try to find a way to solve your problem, but we really can't do that. Now, let me go back to the area I first talked about we're dealing with areas of legal uncertainty. We're dealing with the unclear rules in cyber, unclear rules in targeting decisions in counterterrorism, and we're dealing with uncertainty in a host of different legal issues. And here's, I think, the approach I would suggest that is an appropriate one to take. And that goes back to what Mr. Stevens talked about. We are risk managers. I think that at that point, there are no black and white answers usually within this area, but it's a matter of what kind of risk is going to result from this kind of action. So we can advise our clients that you have 3 or 4 different options to accomplish this mission, each of which has the following legal risk, and talk about the pros and cons of each one, and try to make sure we have a fully informed client, but then let the client decide what kind of risk to take. And I've seen this, for example, where the secretary wants to make a speech, and that speech is going to potentially has consequences for ongoing litigation that we now have against the Air Force. Both myself and Rich Harding, the Judge Advocate General, pointed out the potential adverse effects on the Air Force in that litigation if that speech was given. But nonetheless, an informed secretary who had other larger policy reasons that he thought more important made the call to take that legal risk and move forward with the speech, which is did not upset me, did not upset Rich Harding, because it was an informed, thoughtful weighing of what approach to take. Similarly, with cyber operations, or with space operations, there may be a myriad of not only international legal restrictions, but U.S. statutes, some of which are criminal statutes, where we have to really assess where that particular operation might potentially fall within the scope of that statute. And we give that analysis, we think it's highly likely that that statute will be found not to apply. We think but it's never been tested. And there's a possibility that DOJ may, at a later date, under a different administration, come to a different view. And the risk is that they will decide this was a violation of domestic U.S. law. But lay out that kind of argument. And then the client may decide that despite the fact that that's the case, there is indeed the mission that we're trying to accomplish is of sufficient importance that the space mission or the cyber mission needs to go forward, and because it's just too important. In other words, I think in a lot of these areas of uncertainty, the way you reconcile the guardianship of the law on one hand and the mission enabling on the other hand is you are a communicator of the assessments of the potential risk faced by the client, and the client could then balance that risk against the importance of the mission. And in my sense is that most government officials are pretty risk averse, but sometimes, and I've seen this in a few instances, there's a willingness to take the risk because the mission is so important, or the legal risk is too remote and too theoretical. Second question I want to talk about then is or the final question is what is the role of a government lawyer? Are we just giving advice on the law? Or do we have an obligation to go further? And to this, I think you can turn not only to the ABA rules that talk about how we are advisors. We have an obligation to give not only our legal advice, but our political, business, and other advice as well. But I also point to Harold Coe, who gave a really interesting speech where he talked about the role of government attorneys. And coming from Harold Coe, this was very interesting because he was a big critic as a professor at Yale of a lot of the policies in our counterterrorism battles. And then he came to state and had to grapple with some of the same issues. And he's readily admitted that in some cases his views changed, or in other cases he realized he had a different role. It's a lot different to be an outside critic than to be advising the Secretary of State on something that's really going to happen, is really going to have meaningful impact on people's lives. But he did talk about how lawyers are the conscience of the U.S. government, much as what Mr. Stevens talked about for inside counsel. We are, in some sense, mini IGs. But sometimes, the answer we give, Coe said, may very well say this action is a lawful action to take. Much like we were talking with the Talon rules, where there's a discomfort that the rules of the game that we now have in place, reflected in the Talon approach to cyber, suggest that we can do some pretty damaging stuff and it would not violate international law. It's a counterintuitive approach. And there are other areas too where there are things we're allowed to do that may very well be legal. But he said one of the most important roles of the legal advisor is to advise the secretary when a policy option being proposed may be lawful but awful. In other words, we need to make sure that we appropriately advise our clients on the law, communicate to them that it is a lawful option. Don't try to hide a policy dispute behind the mumbo jumbo of a lawyer. But once you phrase that this in fact is a legal option, go on to give a broader perspective, which means a perspective that takes into account, if you're as a government lawyer, potential fiscal implications, potential international affairs implications, potential political considerations, or real, for those that have some expertise, that a particular legal option may not meet our military objectives because of the kind of fight that we're in. And the potential reactions that people might have, the potential counter moves. And my experience has been that on the issues that we're talking about, in the cyber realm, the detainee affairs realm, the legal discussion is usually about the first 5 minutes of when Rich Harding and I talk to the secretary, that we spend the next 25 minutes talking about the pros and cons of the various kinds of options. And we're in the room with the operators, but our views on the wisdom of a potential action, either politically, militarily, fiscally, are given weight. I've heard this from several commanders who talk about oftentimes the smartest, brightest officer on their staff is their JAG officer. And JAG officers' views on the military issue, if they are good, smart military officers and not just good, smart lawyers, can oftentimes carry the day. That lawyers do have influence, and as long as we are careful to let the client know when we are talking as lawyers and when we're giving larger policy advice, as long as we have knowledge and credibility to speak with some background on beyond our expertise, that can be a very important role to play. Because sometimes, again, we're talking about very difficult decisions where we're being pushed to do something for a short-term reason, but there may be long-term implications, and it's our job as a lawyer to think beyond it. And it's not just Harold Code who tells you to do this again. It's the ABA model rules talk about the role of the lawyer inside government and outside government is to have a much broader reach as well. So with that, the sort of theme that with an area of uncertainty, I want to talk about one area where there is a lot of certainty, but it's also it's a very important part of the job, and that is in the joint ethics regs. One of the, I would say about 20% of my job is being the legal ethics advisor to the senior Air Force leadership, and I'm the top ethics lawyer for the Air Force as pursuant to a delegation from the Office of Government Ethics. And as you may have read and was discussed earlier, we've had a series of mishaps by some fairly senior officials across the Department of Defense, not only general officers, but SESs as well, where we've had issues with compliance with ethic regulations. In fact, if you look at the number of allegations of misconduct by senior DoD officials, and this is true of the Air Force, the Army, and the Navy, there's actually been quite a large increase over the last few years in the number of IG investigations, and many of which are substantiated in recent years. My personal view is it's not because we have a less ethical military leadership. I don't think that's what's going on. But I do think we've had one positive development, which is people feel more empowered to file IG complaints. Whistleblower protections are beginning to be real. And we have a lot of people who are more willing to drop a dime on activity that they view as unlawful. That being said, the reality for the leadership of all the military departments, from the brigade level and the wing level on up, is that we are under scrutiny, and our activities are being watched very, very carefully. And we have an obligation as lawyers to make sure our clients get the ethical advice they need. And in my sense, most of the problems I see are not because people got legal advice and ignored it, although that has happened as we discussed the case of Kip Ward. More likely, it's that the lawyer was never asked to begin with, which means we need to be a lot more proactive in getting the word out. And what our office has discovered is it's usually not the 4-star general or the 3-star general who's the instigator of the ethical misconduct. Usually, it's the military assistant whose job it is to fully support the commander, who will, not understanding the rules, never being trained on the rules to the extent that the general officers are, start doing things that are on behalf of the general officer that are inappropriate. And so one thing we've been trying to do is do more training of military assistants. We have a guide for military assistants. And now we've taken the next step. The next source of many of these problems are spouses, who again are never usually not told what the rules are. And we now are beginning to as part of the normal training of new general officers and new commanders, is actually meet with the spouses and make sure they understand the lay of the land. And in some cases, these rules can be counterintuitive to, and they're not about personal gain whatsoever. They're about why a nonprofit. In fact, we heard mentioned last night about rules that prevent us from being fully supportive of nonprofits that want to come under our basis and help us. And we just need to make sure people understand what those rules are. So with that, I'll stop, and I'm happy to answer questions on anything, including things I haven't talked about. Yes.
If I could kick off the questions, we have a lot of young lawyers in the audience. In government in particular, the young lawyer may be the only lawyer at a meeting. And from a nuts and bolts perspective, what advice do you give to those young lawyers? What advice would you give to those young lawyers when they hear something that doesn't seem to make sense? Because in some circumstances, they may not know what they don't know, but it's not sounding right. But if people walk out of that meeting that sort of thing. How do you address that kind of dilemma?
I usually, if they have doubts about the potential legality of what's being worked out, especially if it's an area beyond where they are, they can always use the "I need to talk to my boss" excuse to buy time to get the right result. And sometimes it's personality driven. Some clients are very receptive and they don't care that it's a young lawyer or a captain giving them legal advice. If they trust you and they know you, you can speak up at the meeting. Other clients, quite frankly, it would not be productive to bring up the legal advice at that meeting. And if that's the case, top cover is a well-known tradition that we're happy to facilitate. What I will say, however, is that the one thing I'm very impressed by the Air Force JAGs that come to my office is, and we get people at the senior captain, junior, major level, and most of whom have been both defense counsel and prosecution, which I think is a critical thing to have happen, is they seem to be completely without concern about giving unwelcome advice to clients. And a lot of them can do it in a charming, thoughtful way. And I have one young lawyer, a young major on my staff who I love to brag about, who worked for Kip Attlee, who was one of my deputies, who is retired, a colonel. It was sort of an institution within the Pentagon, who is very sure of his view of things. And this young major, who was not only willing to disagree with Kip's views on things, but convinced Kip that he had been wrong. So that's what you want in a young lawyer. There's an element of courage. It may not be physical courage that's required of a military lawyer, but there is certainly an element of moral courage that I think we need to encourage in our younger lawyers. And it's the job of general counsels and staff judge advocates to protect our people. Fortunately, I rate them. They're not rated by the clients, which I think offers an element of protection and independence. But sometimes, again, you need to know your client, and sometimes letting your boss give the unwelcome news is a better way to go. And that's a job I cheerfully do in appropriate cases. Yes?
George Walker of Wake Forest. As a reservist, I was on active duty once and had a line skipper found out I was a lawyer. I always hide that, but he found out. And he asked me about something and said, well, this is the way I want to get it done. And the getting it done would involve not only lawyer-client problems, but I think at least one or two other counseling ethics violations of other professionals. And what I did is I finally ended up conferring with his exec and suggested an alternative route. And the thought I've given a lot of our students when they've asked me is, I said, look, if it's wrong, okay, but see if you can figure out a way to tell him, well, Captain or whatever, Admiral, here's another way to go about it that might achieve the same result with a lot less difficulty, and put it like that. It seems to work.
Yeah, I think I never like to give a flat no. I always like to offer at least an alternative that's closest to what you want to achieve. And really, the real answer is, and we will show up at meetings we're not invited to if we think that they're going to be developing options that the senior leadership is going to be given. Because if a lawyer is involved early on in the brainstorming of a solution to the problem, 99% of the time they can find a lawful, legal, ethical way to meet the mission objective. Or at least they can educate the clients who are developing the options about what the legal hurdles all are so they can be avoided. But barring that, then the job becomes to struggle to find something that at least comes close to meeting the mission objective. And I had a when I was at the Army, I had a deputy, Matt Rearis, who did both fiscal law and ethics law, and he used to talk about how in the area of fiscal law, which was really about meeting the objectives of the Army in a particular circumstance, and to help a commander do what the commander needed to do. He was willing to be as creative as possible, and being upfront about what the legal risks are, but offer options that might be a little out there if the mission was important enough. But in the ethics area, which is usually about whether can I attend this dinner, can I accept this gift, he said my creativity went away. He operated in the gray area, in the fiscal law area. He'd never operated in the gray area when it came to the personal ethic rules. And I think that's another area where we need to understand is that there are some areas of the law where to be missioning enabling means you need to be creative and be willing to operate in the gray area with full disclosure to your client that you're in the gray area to make sure they want to operate in the gray area. Well, there are other areas where, for example, there may be a criminal statute. There may be severe consequences for the Air Force if we get the answer wrong, or it's about personal ethics where you do your client no service if you try to find a gray area yes when the appropriate answer may just be a flat no. No, you can't go to that dinner. Some over here?
Couple questions.
And then one over here as well.
I just want to subscribe to Charles's comments, and I think he's hit the nail on the head. Particularly your comment about courage, there does come a time when courage is the essential value, and it reminded me of, which I like to talk when I talk to my folks, is Churchill's comment that without courage, all other values lose their meaning. And at some point, you get pushed to where you do need to be courageous. Now, I've also been reminded that Churchill said, when you're going through hell, just keep on going. So you can take your pick.
That's the wonderful thing about Churchill. He's got a quote for everything. And then we had Professor Schmidt down here.
Professor Silman and Professor
Sure.
We'll get going.
Let me bring Mike in on my question or my comment. I think it's obvious that the lawyer needs to be well skilled in the craft of lawyering. But it seems to me, whether we're talking about private practice or whether we're talking about government service, that the lawyer also needs to go outside his comfort zone and really, really know the business of his client. For the military lawyer, he's got to understand all about the mission so that the legal advice he or she gives is within the context of that business. If the lawyer stays in his office with his law books, he does not serve his client well.
Oh, I absolutely agree. In fact, one of my favorite stories about the Air Force JAG Corps was there was a targeting discussion that was going on where there was going to be looked like there was going to be an unavoidable collateral damage, and everyone was talking, and because of the ROEs, not because of the rules of law, it looked like this mission would have to be scrapped, and then a paralegal said, if you change this weapon system to this weapon system, I'm pretty sure you're going to find that the collateral damage will be over here, not over here. And that was an example of a paralegal knowing the client well enough to actually be a major contributor and became a mission enabler, not as a lawyer, or a paralegal, but as an operator. And I certainly, I work for clients in my private sector life who insisted that the lawyers who worked on their matters really understand the company. The Intel Corporation was probably one of the best examples. And if you worked on an Intel matter, you went to boot camp and you learned all about Intel. You learned Intel speak. You learned how they did product development. You knew how they were organized because they wanted lawyers that understood their business, and they expected you to keep up on the trade. They really fully expected you to understand the client, and that's certainly my philosophy with the Air Force as well. I try to be tougher with the no travel rules that we have imposed on us, but I try to get out and talk to folks as much as possible, so I understand the business of the Air Force. And I also, fortunately, have a boss, a secretary, who includes me in meetings that may have no legal import whatsoever, but there are larger policy issues, so that I'm fully aware of what's going on. For example, I attend the quarterly meetings, or the monthly meetings where we discuss our foreign military assistance to the Afghan Air Force. And that had, potentially, in a few cases, it's been very beneficial on legal advice, but its main value is understanding what it is we're doing, why we're doing it, what the challenges are. So it gives me a better sense of what the needs are. And then you can know what's time urgent, what's not time urgent. I mean, I think it's any lawyer for any organization has got to understand their client's business if they want to be successful. Professor Schmidt, I think, had a question.
Since we're here at Duke, where we have the godfather of lawfare, let me ask a lawfare question. I have a real sense that there is a lack of transparency with regard to U.S. government legal policy. We mentioned it last night briefly in the bus. For example, cyber, we rely upon Harold Koh's speech to set forth what the U.S. policy on cyber is. It's a very short speech, and when it was subsequently published in the Harvard Journal of International Law, they were forced to add footnotes to it so they could explain the legal logic. Targeted killings, we have a DOJ white paper, draft white paper that is released.
Not even released. Yeah.
I'm sorry?
That was leaked, not released.
Leaked. That's exactly right. Leaked. And in terms of its international law analysis, it's absolutely unexceptional. I mean, it's a rational, logical application of international law. There's nothing surprising about it at all with regard to the international aspects. We were fighting in Afghanistan and Iraq. It was clearly a non-international armed conflict, but it took us a long, long time before we would mention that. And so when my problem is we're not being very transparent, and when we are transparent, we tend to do so in speeches. You know, Harold Koh makes two famous speeches, one at ASIL, one at Cyber. Jay Johnson goes to Oxford and Yale and makes his speeches. The Attorney General goes to Northwestern. And it just strikes me that speeches aren't a very effective way of being transparent about what a nation's policy is with regard to killing people or engaging in cyber operations. And it seems that even when we make the speeches, it's well after the fact and well after the battle lines have been formed. I mean, again, we've discussed a little bit. There are issues that are popping up on the scope on a constant basis by academics that really need to be put back in their box. And it isn't until much, much later that that's done. And in the interim, it's left to other academics to engage in dialogues on blogs and so forth. So are we doing the lawfare piece that Charlie talked about well?
Speaking for myself, no, we are not. I've tried, actually. I have a blog. I've got my office is a blog. My office is a Twitter feed. We're trying to be out there. So far, we have not been slapped down, but we've been careful. We've been careful to expose the ideas, but understanding if we comment too much on them, we're going to be slapped down. The problem, I think, is this, that each of these issues is not just an Air Force issue or a DOD issue, but usually in a counterterrorism, it is an intel community, it is state, it is justice who's defending lawsuits, it's the Department of Defense that may be involved, and it's the NSS staff. And I think what happens is that the speeches you all read are the result of a consensus that was reached, that those speeches and the content of the speeches was approved by the interagency process. But anyone who has seen any controversial issue that requires any interagency coordination, it takes months, if not years. So I think we are paralyzed by the interagency process. But it's hard to find a way the State Department has an interest in our declarations of our views on international law. The Department of Justice is right now litigating cases that could be adversely affected by what statements are made by the Department of Defense on a particular matter. So there's real reason for the interagency to get involved. I think the main problem with lack of transparency is actually we are not thinking in real time to keep up with all these issues. So rather than think through an intelligent, thoughtful, global way about what all the potential legal issues are going to arise from a counterinsurgency activity, we address each issue as it comes up, come up with a decision that probably is correct as a matter of law, because there's a lot of lawyers working on it, but we may not all agree on how we got there. And then when it comes time to articulate how it is we got there, that's when we argue. We all agree that what we're doing is legal, but we all have different agreements. Is the Article 2 authority of the president that allows us to do that, or is it the authorization for the use of force? Both viable legal theories that can be used to defend an action, and different parts of the U.S. government have different views on those two, and the wisdom of asserting those two. So we may agree it's legal, but we don't agree why. So I think the challenge of us is to get out in front on these issues, and I think we have the ability to do that with cyber. I think we're doing a lot more work in cyber, so we'll be in a better position to articulate our policy positions, and hopefully then we can be transparent up front, as opposed to having to be trying to be semi-transparent in defending what we're doing. But I think the real answer is these are tough legal issues with varying degrees of agreement or disagreement within the U.S. government. And so oftentimes what you're seeing is the speeches are the best way to proceed, I think, the best that can be happen. But my personal view is we're doing ourselves no favor. I mean, I would take transparency even further. I wish we can disclose more about what we know about civilian casualties, because we can't and don't for probably good reasons in some cases and not so good reasons in the others, because we can't talk about with much specificity about particular operations. We can't disclose what we know about why we allege there were few, if any, civilian casualties. And so because we don't do that, the only reports we get are secondhand, third-hand accounts out of one of the most unreliable areas of the world, the Fatah or rural Afghanistan or rural Yemen. So the worst is believed. So I think it's a long-term interest in the United States for us to get our act together to be more transparent, not only on the law, but on what's really happening on the battlefield. And my sense is if John Brennan is the next CIA director, which may happen in the next few weeks, with Hagel at Secretary of Defense and with Kerry at State, we may be able to move toward a more transparent U.S. government.
Speaking of, go
Tom Houck, just a private citizen. Just out of curiosity, how much of your thinking goes towards the next administration being angry at what you've decided now, or how much now is the current administration going against the previous administration? I mean, how much is that?
Yeah, in my job, not a whole lot. There was atmospherics when I first got on in my current job about the relationship between my office and the JAG Corps. That was, in my view, a broken, unhealthy relationship. And so I spent an early part of my time, I don't know, Charlie can say whether I was successful or not, to try to right that relationship. And I think right now the relationship is pretty darn good. That we're really partners serving the same client. But a lot of the legal issues, I mean, I think there's real value in continuity. Now, I can say that early in the Obama administration, we tried as much as possible to offer legal arguments that were not wholly dependent on the president's commander-in-chief authority. We always tried to find other domestic law sources for authority, and didn't disavow the commander-in-chief, but because the commander-in-chief authority was such a theme in the early Bush administration, we tried to move away from that. But if you look at the legal advisor writings by John Belanger in the second Bush administration, or you look at what was written by the Office of Legal Counsel in the second Bush administration, they had already pretty well disavowed some of the more aggressive positions of Bush 1 on commander-in-chief authority. So there was a lot more continuity legally between us and Bush 2. There was not a whole lot with Bush 1. So we didn't, so I guess my point is that John Bellinger, Jack Goldsmith had already moved in the same direction we were going in, and we just continued that legacy. And I really, my sense is the consensus we have within the current administration is probably not all that different than what we will see in a next administration. There may be a more aggressive or less aggressive exercise of executive power, but there is some continuity. And there were some areas, where detainee policy changed. We supported the adoption of a Military Commissions Act, helped by the Supreme Court. So we've done things that maybe a previous administration would not have done. But I would also argue that, some of that legwork had already been done by people like John Bellinger and Jack Goldsmith. Yes.
My name is Richard Ellman. I'm a retired citizen of Durham. Let's assume that you gave advice to your senior people, Secretary of Defense even, or the President, and your advice was it's clearly illegal, but for whatever the national security reason, he opted to ignore your advice. What do you do?
Well, it depends on, what the rule is. I mean, given that my client is the Air Force and not the Secretary, unfortunately, I have not faced this kind of decision. If it were a real serious violation of, that, then I think, raising it to higher levels is critically important, and that's part of the courage statement that I have. And I think in our history, you've seen some of that being done by lawyers who have, the General Counsel of the Navy had a very different view of detainee policy than some of other colleagues, and raised the issue as high as he could within the Bush administration, and ultimately his opposition became public. Similarly, you've seen the case of both military and civilian career lawyers within the Department of Defense who made very clear their views of disagreement. So I have not yet faced that circumstance. I've got clients who listen to my advice, but I do think that if your obligation is to the institution, and you believe that the current leadership of that institution is making an illegal decision, then I think you have an obligation to raise that to the Secretary of Defense. And then the lawyer for the Secretary of Defense can decide whether what I did was right or not, and go from there. But I think there is an obligation if your client is the institution.
I'm Lieutenant Colonel Steve Strickey, Canadian JAG. Thanks, sir, for the great presentation. Just from a comparative perspective, in our model, our TJAG is the advisor, for instance, to the Minister of National Defense in all matters of military law, including operational law, military justice. With regards to, just to nuance that last question, when we're not dealing with issues of clear illegality or something that you would feel is illegal, how could you describe how you may deal with ethical issues where you feel a legal avenue is the preferred avenue, for instance, perhaps internal within the Air Force, and you may conflict a little bit with the TJAG? And also, could you comment on if you and the TJAG are at item on the preferred course of action that differs with perhaps a joint endeavor by the Army and Navy, for instance?
What we try to do is, and this has happened several times, is if Rich Harding, who's the Air Force TJAG, and I have different views as to how to approach a legal problem, we will try to meet and come up with just talk to ourselves, talk amongst ourselves. we had at least one meeting where I left the meeting agreeing with him, and he had left the meeting agreeing with me, so we had to come back again to repair the advocacy that had occurred. But in most cases, it's not, I would say, I've never had an instance where I disagreed with his view of the law, as much as we have made disagreement about the tactical or strategic approach to how to handle a particular matter. So it really wasn't a legal dispute as much as what our settlement offer should be in a case, whether we should settle a case or not settle a case. And so in those cases where we didn't reach agreement, we just did a joint email to our client, laying out what we agreed on, and then the two potential courses of action, and then each of us wrote the pros and cons, and just said, the GC prefers this option, the TJAG prefers that option, and with pros and cons, and then let the client make the decision. We have a statute that requires that the TJAG have full access to the secretary. So, but in most cases, we resolve. My experience has been that we get both of us in the room. We come at the problems with a different perspective. My perspective is coming from the private sector, my private sector experience. His experience is from decades of advising commanders out in the field. And so we have a dialogue about how to approach the problem. And in most cases, we end up at the end of the meeting with a much better analysis and a much better, a more nuanced approach to the problem that we're able to present to the client that takes advantage of both my experience and Rich Harding's experience. And that has been a real challenge. There are other areas of law that really are challenging. One that we're grappling with right now is First Amendment rights of military members who block. And we have very different views on the policy issue, but we're grappling with what are the First Amendment rights or not rights of the that's an example of where his experience out in the field, and in my experience in the private sector, quite frankly, representing a lot of newspapers, so my perspective is maybe a little bit too much of a First Amendment zealot. But the combination of the two of us, I think, is resulting in a sensible approach to the problem that takes account of the unique features of military life while still maximizing the right to express views by military members.
I think we have time for maybe one or two more quick questions.
I'd like to follow up again on this latest line of questioning. Do the tactical people always consult with your legal staff first before embarking on a new kind of mission? And similarly, if in fact they don't, and you learn about it after the fact, what is your recourse at that point?
Well, in most cases, a tactical level legal advice is not given by my office, but would be given by the wing or major command staff judge advocate who has the responsibility. But there are a few entities within the Air Force, mainly in the black world, where there are clients within the air staff, but they're doing things that are tactical or operational. And fortunately, they have learned. They've learned because we've said no at times, and they had to go back and completely redo things. They've learned to get us involved sooner rather than later. So they'll get us involved before they do an MOU with another agency. They'll get us involved before they develop something. And there's actually in the SAP world, they're required to, by a thing called the John Hamre rule, to get a legal weapons review of any new weapons system before we've spent a whole lot of money developing it. So, but there have been a few instances where our clients, bless their heart, have gone down a road toward trying to meet an objective. Usually it's on the operational area. Usually it's in the real estate area, or solar energy is really cool right now, so a lot of people want to put solar energy everywhere. And and they sometimes don't understand all the they have to consult with Indian tribes, all these legal requirements that they're just not aware of. And they learn very quickly that the consequence of not consulting us is that we gave them a big homework assignment of 7 different consulting things they need to do to meet that project that's going to delay them by a year. And if they had consulted us, we could have helped them do that concurrently with the development of their proposal. Or sometimes they go ahead and they do something and it's done, and they end up having to have a Anti-Deficiency Act investigation or an IG investigation, which is never pleasant to have. So the IG and the fiscal team are sometimes our best enforcers of getting us involved.
Well, thank you very much, Mr. Blanchard. Before, I think there's one little addendum that I do want to make to this ethics discussion, and in fact, it's a lawyering discussion as well. Mr. Blanchard alluded to it when he came into office. There was a dysfunctional relationship going on. And there, no pointing fingers as to why that was and how it came about, but it's very complex. But I think in the realm of national security law, and especially in the ethics area, because so many things do lack the transparency, the individual ethical moral compass of the individual lawyer is very important. But in addition to that, as much as people think that government is a big entity and this monolith or whatever it is composed of individual human beings. And individual human beings who reach out, who try to connect, who try to make things work, make all the difference. And when it comes at a very senior level, it made all the difference in the United States Air Force in writing that relationship, because what was so terrible about that relationship before Mr. Blanchard came was that the clients were the ones who were really suffering because they didn't know what to go on, and they were playing one side off against the other in a very unproductive way. And that's the way you get all kinds of problems, ethics and otherwise. And I really thank you, Mr. Blanchard, for your service in that regard and fixing that problem. Thank you. I really do want to hit our time on target of being finished at 12:30, but I want to reiterate my thanks to everyone who helped to put on this conference. And you remember the first day I went through the many people that were involved. I really can't thank them enough. And I also can't thank our speakers enough. We don't pay honorariums. We don't, do a lot of things for our speakers. And like I said, we had the A-team show up here, much to my shock and surprise, but great pleasure. And I think we all benefited from it. The other thing is that I'd like to leave you with is that it's great to have wonderful presentations. It's great to have the experts come in, but the real value of a conference like this is getting to know each other. And it's those discussions around the coffee pot, it's discussions over the dinner table last night, and I hope that you build these relationships and carry them on from this conference, because that's really one of the reasons why we still want to have an in-person conference, and it's not just going to be by VTC. And for the young lawyers in the audience, I want to close by foot stomping something that my colleague, Professor Solomon, or Judge Solomon said. It's so important to learn the client's business. The wonderful thing about this conference is that it wasn't just lawyers. Or just, people from government, even government lawyers. It's a mix of people. We had people from industry. We had people from other disciplines. We have law students, military lawyers. It's this mixture, this interdisciplinary approach that's so important. Because as Judge Solomon pointed out, you really can't practice in this area. And I would say if you're a client, you can't be effective in this area unless you really know each other and really know the respective interests and needs and basically each other's business. So with that, I do want to invite you to give me feedback. How can we make it better next year? And I particularly would like to know what your thoughts are on subjects that you would like to see considered next year And I want to thank each and every one of you for coming to this conference. And so great to see a full room on a Saturday. And before I do want to thank my wife, Joy, who's had to put up with, shall we say, a few stressful moments. In any event, thank you very much. Safe travels. See you next year.